Good afternoon, everyone, and welcome to Sponsor Symposia number 8, titled Risks and Rewards of Virtual Services. My name is Derek Dow, and I'm the focus group leader of the International Miscellaneous Medical and Life Sciences team at Beazley. I'm thrilled to be one of the presenters of this symposia, sponsored by Beazley at eHealth 2022. Joining me today will be Heather Pfeffer, Claims Manager at Beazley, and Imran Ahmad, Partner, Head of Technology, and Co-Head of Information Governance, Privacy, and Cybersecurity at Norton Rose Fulbright. This session will consist of a live presentation, and if we have time for audience questions, we'll address those at the end of the session. You're also encouraged to connect with any of us after the sessions via the virtual event platform. In terms of our agenda today, we'll start with Beazley's view of the digital health industry, the exposures we believe to be present, and how our virtual care product is designed and well-placed to protect clients. Heather will then review the specific impact of COVID-19 on the digital health industry and the changing landscape, including claims considerations and specific telemedicine claims examples. Imran will wrap things up for us with a deeper dive into the privacy concerns and considerations faced by the digital health industry. With that said, let's get the conversation around risks and rewards of virtual services going. To set the stage, I think it's important to start with defining the universe as to who we would view as potential insureds from the digital health industry. As you'll see from this list, these are entities who both provide services directly and also entities who support those who serve patients. Services can be both clinical and non-clinical in nature and often do include direct patient care. In the interest of time, I'll not spend too much time individually diving into each of these buckets other than to say two things. In our experience, clients would we would categorize clients as falling within the telemedicine to be what most people will think of when they hear the terms e-health, digital health, or virtual care. As I'm sure we'll all agree, the industry is so much more than this. So we spend a lot of our time on education and explaining to brokers and clients just how broad coverage can be under virtual care and how broad the insureds can be under the product as well. In our eyes, it is not always crystal clear into what specific bucket a client may fall into, which is fine. What matters is the identification of the specific exposures faced, which is how we craft our virtual care product to fit a specific client, something we'll go through more shortly. We first launched our virtual care product in 2017 in an effort to address what was quickly becoming a patchwork of insurance policies that digital health firms required in order to address all exposures present. This evolution is not dissimilar to what we have observed in other industries within the insurance sector. Perhaps one of the more interesting aspects here, when considering digital health, is simply the breadth of exposures a single entity may have when operating in this space when compared to others. As this graphic shows, the exposures faced by an insured can be as broad as the services they offer, and hence the need for a number of insurance policies to be placed in absence of a package policy such as virtual care being available. We would suggest the majority of the clients we deal with face similar exposures, as the graphic sort of indicates, however, in varying degrees, and thus require coverage to be tailored accordingly. If we start on the left-hand side, and perhaps somewhat obviously, providers using technology to deliver care will typically have the highest degree of what we would call professional liability, med-mal, or medical malpractice exposure. On the other end of the spectrum, we have designers and developers. These are companies or physician groups that create, develop, or purchase platforms that bring providers and patients together. They may not directly deliver healthcare services, but instead match patients with providers, acting as the supply and demand throttle. Their predominant exposure may be more related to the technology errors and omissions and a failure of the platform to perform the service as prescribed, but will also have some contingent and perhaps direct, depending on the setup, medical exposure. Somewhere in the middle rests our platform hosts. We'd expect insureds in this sphere to have elements of direct PL from direct patient contact, as well as tech E&O from the service being delivered on a platform type solution. And importantly, across the board, we'd expect there to be serious privacy considerations given the nature of personal health information, or PHI, many of the clients in this industry would have in their possession. In several cases we've already seen, it has been the privacy exposure and the overall number of records really driving premiums and coverage needs for our clients. Very quickly, this graphic represents what we believe to be the core value proposition of our virtual care product: affirmative bodily injury coverage across all of the different insurance agreements available under the policy form. The importance of this feature will become more apparent as Heather walks us through a number of claims considerations and examples, who I'll pass the floor over to now. Over to you, Heather.
Thank you so much, Derek. So I want to talk a little bit about how the landscape changed when COVID-19 hit and what we're still seeing as we kind of hopefully come out of the pandemic. So if Derek, you could go to the next slide, that would be great. So when COVID struck all of us in 2020, the world pretty much halted, but then a lot of things didn't stop. And that was specifically the delivery of healthcare and of telemedicine services. So what we saw at the beginning of the pandemic was a huge uprise in brick and mortar companies that were offering telemedicine services. Some of these companies had never really dipped their toes into telemedicine before the pandemic, but obviously the increasing need created the desire to do so. So in line with that, we also saw existing telemedicine companies kind of expanding their scope of service and providing services that may not have specialized in prior to the pandemic. So it was a lot of learning as they went. One of the things that we have seen over the last 2 years as we've kind of lived through the pandemic and hopefully have kind of seen the light at the end of the tunnel is that public opinion towards telemedicine is becoming more positive, and it's changing a lot. And I'll get into that in the next slide. But I think the biggest thing is that prior to the pandemic, telemedicine was something that every healthcare organization was talking about because folks appreciated the benefits it could provide. But I think providers and even patients were very slow to kind of adopt telemedicine in their everyday practice and in their everyday how they got their health care. But that has changed, and I'll talk a little bit about that some more. As the pandemic hit, like I said, it felt like there was just a lot of rush to address the need that was emerging as far as telemedicine services. So what we also saw was a lot of carriers were either non-renewing, they were pulling quotes, they were adding blanket exclusions to cover COVID or communicable diseases because we weren't quite sure what types of claims we were going to see once we kind of emerged from the fog of the initial pandemic days. And again, I want to emphasize that there has been a greater confidence in telemedicine. Folks, and whether that be doctors and providers or patients, have been using telemedicine more frequently now over the last couple of years. And they found that it is a reliable and dependable way to either provide healthcare services, or if you're a patient, it's a great way to receive typical and routine and follow-up healthcare services. Derek, if you wouldn't mind advancing to the next slide. So again, just to further highlight some things we've seen in the telemedicine space since the pandemic. This was unfortunately one of the earliest and the most recent data points I could find, but before the pandemic hit, telemedicine use was steadily increasing, but it was just 0.15% of all billable services in the Canadian healthcare system. And again, that was back in 2015. And I think that was steadily increasing. But again, when the pandemic hit and patients were advised to stay away from their doctor's offices or from hospitals unless absolutely necessary, that obviously created this need for folks to receive care telephonically or by video. So since the pandemic hit, and in 2020, there was an increase of 44% in telemedicine visits. And again, some of that was by need, and a lot of it was by the fact that folks started using telemedicine and found that it was a reliable and easy way to see their physicians. Again, the biggest thing that we've seen over the last 2 years is a higher patient satisfaction score. There's an organization called Press Ganey that does patient satisfaction surveys amongst a lot of the US hospital organizations, and they have specifically studied this from the endpoint user and have found that patients have greater confidence in telemedicine. And a lot of those hesitant users were the folks who may have been older, they may have been less tech savvy, so they didn't feel like they were getting the same quality of healthcare. But as these patient survey results have shown us, those patients actually feel that they're receiving the same quality of care in telemedicine. So it's increased the demand and it's increased the numbers of visits we've seen. Another huge driver in the boom in telemedicine is a relaxation on traditional licensing issues that we've seen. Again, this was something that was happening all across the country and the world because people recognized that even though there was a pandemic, folks still needed regular, routine, and follow-up medical care regardless of the pandemic that was happening. So there was a rush to relax licensing requirements so that folks could access medical care despite where their clinicians were licensed. So we've seen a lot of that. And we're starting to see countries and territories try to grapple with what's going to remain and what do they need to dial back on now that the pandemic is hopefully, quote, getting better. Derek, would you head to the next slide? Thank you. So I want to talk a little bit now about the claims overview and what we've seen from a claims perspective over the last 2 years. Generally speaking, 30% of claims involve claims against providers who utilize telemedicine to evaluate a patient, and then unfortunately, in retrospect, made the wrong judgment call. And so these are going to be your situations where a patient set up a telemedicine visit with a clinician, and the physician probably should have caught on to something that should have been followed up on either in an urgent care setting or maybe even in an emergency department situation. So a lot of those claims result from a scenario where the plaintiff is alleging that the telemedicine provider should have been alerted that something more serious was going on and should have referred that patient to an actual in-person visit. A huge component of the claims that we see result from behavioral health. So that would be a lot of the therapy or the counseling services, a lot of those platforms, which again have become increasingly popular since the pandemic. But those are the claims that we're seeing a lot of. And then the diagnostic or testing laboratories as well. A lot of this, again, was happening before the pandemic. So we'd have insureds where they may read an EKG remotely. The provider was in one position, and then maybe the community hospital couldn't staff that particular specialist on site, so they would farm those services out via telemedicine. And that's, again, where you've got a claim where the provider is not on site with the patient, and so they're not able to go to the floor and see the patient and actually perform an hands-on assessment. We've also seen some claims from medical staffing fields, which, is something that, again, we saw pre-pandemic, but I think it's just something that has consistently borne claims out over the last 2 years. The good news is that to date, the types of injuries and the severity of those claims in the telemedicine space is not any more severe than you would see in a traditional healthcare setting. So if you've got a failure to diagnose claim that was done via the telemedicine platform, those claims are not going for more money than a failure to diagnose claim in a traditional hospital or inpatient setting. Derek, do you mind going to the next slide? Thank you. So now I'm going to kind of touch on some of the different spheres that Derek talked about, things to consider from different perspectives. The first being professional liability. So I think when you look at telemedicine and what happened over the last 2 years, and it's interesting because as the statutes of limitations start to come up, we're seeing claims that have either happened over COVID or didn't turn into anything come up. And so the question is, did COVID change the standard of care? I mean, typically, we don't think so, but again, a lot of that is to be seen as far as whether these claims are actually litigated and how a jury is going to judge a practitioner who is providing care in a telemedicine setting versus, again, seeing a traditional patient in their office. I think the onus is always going to be on the provider in this type of situation to know the limitations of what a telemedicine visit can do. So again, most of those claims are going to come out of a plaintiff saying, you should have done more. You should have referred that patient to an inpatient visit. And so again, it falls onto the provider to appreciate when the patient should be seen in person and a telemedicine visit is not enough. So some of the risks and concerns that we've identified in the PL space are the failures to intervene. So again, you've got limitations of diagnostic testing when those are done remotely. So if a patient has a telemedicine visit for an issue with a rash on their chest, if a physician is doing that consult via telemedicine, they're able to see it, but they may not be able to appreciate the rise and fall of the patient's chest if they were in person. So again, the provider has to appreciate the limitations of a telemedicine visit and account for all of that in their assessment of the patient. Website manner is an interesting concept because a lot of the problems with telemedicine is that personal connection that a physician can make with their patient is very hard to do over video or over a phone call. So providers have to be aware that you're going to lose some of that connection when you're doing a visit telephonically or via video. So they have to, again, take into consideration the fact that they are communicating with a patient by video, and they may have to be more in depth or more specific than they were if that patient was sitting just across the exam table from them. Provider burnout is something that we were concerned about at the beginning of the pandemic, again, because I think the number of telemedicine visits had just skyrocketed. And the concern was, I think everybody was at home and in front of a screen all day, and the screen burnout and screen fatigue was very real. And so again, I think that translates to medical providers. If they are just seeing patients one after the other via telemedicine visits, again, that is going to increase their fatigue or their burnout, just like it did for all of us sitting in front of our laptops 8 hours a day in our home offices. Informality leading to inappropriate conduct in relationships is, again, something we're seeing more in the behavioral space when it comes to telemedicine. And I think, again, this was a risk in a traditional setting with a therapist and with a patient. But again, I think that there's some kind of breakdown that maybe happens with a video call as opposed to being in person. And some of those barriers that a clinician may put up with a patient aren't there. And so again, it can become a little more impersonal, and you just have to be aware of that. And we want our providers to be aware of that. Consent issues is another one, because again, when you're having a visit with a patient via telemedicine, you have to make sure that you are going through all of the issues of the consent, that you can appreciate that they appreciate the risks that you are relaying to them. Because again, a lot of that, the cues that may be picked up on in an in-person visit may not be there in a telemedicine visit. So it is incumbent upon the providers to make sure that a patient is being consented properly and really appreciates everything that the provider is telling them. And this last thing that I put on here is the issue of hometowning, which is kind of interesting. And we saw it come up in one of our recent claims, where if you have a provider who, again, is maybe providing services remotely, and a claim comes up with whether that specialist read, let's say, a radiology study appropriately and then relayed the results to the provider on site, there's a concern that, because we've seen it, where the physician and the organization kind of hometown the outsider who was not on site. And again, it's not something we've seen a huge spike in, but I think there is some concern where if you have kind of the outsider or the physician who is off-site and not personally interacting with the other providers of the patient, there's a concern that it's easy for the folks that were in person to maybe push the blame onto the physician or the provider they've never met before. Derek, do you want to advance the next one? Thank you. So this is something to consider from the tech and the E&O perspective. The biggest things is we've got all of these new medical software and tech supports and platforms, which are wonderful. But the question is, how are those, what kind of standard of care are those going to be held to? Is it going to be the typical medical negligence standard of care we're used to, or is it going to be something a little higher like strict liability because you're dealing with an actual product? So again, we haven't seen a lot of litigation come out of the E&O space, but that is something that we're considering and we're very aware about. So risks and concerns obviously associated with these different new apps are, you want to make sure that they are so wonderful, they are so convenient, but a physician, again, needs to make sure their patient is not placing too much reliance on that medical device. So if you have a portable EKG device that your patient is using at home to monitor themselves, the provider has to still appreciate that the patient knows there are limitations to that device. And again, I think there's going to be an argument that the manufacturer of that EKG device has to also appropriately advise the patient that there are limitations to that. Patients and consumers are often self-treating themselves, self-diagnosing, self-treating themselves. So I think the concern, again, is that a physician is involved in the treatment plan and is aware of what the patient is doing as far as whether they are monitoring their heart rate and so that the patient knows the appropriate steps to take when their heart rate might be out of the normal rhythm. Medicating based on the same is another thing where you've got so much ability for patients to monitor their own symptoms and to monitor their own vitals. And then again, unfortunately, to maybe monitor their own medication. So it's just something, again, where you've got these wonderful devices that are on the market for us to use at home and to monitor our own health, but it is very incumbent upon the providers and the developers to make sure that everybody is aware of the limitations that are there. Product usage or failure is another one. There was a kind of infamous situation where it was like a blood sugar monitor that was mostly used for children. And they had a situation where the server went down. And so there was a period of blackout time where children's blood sugars were not being appropriately reported if there was like a concerning spike. And so there were several claims that came out of that period, that blackout period. Unfortunately, good thing no children were seriously harmed. But again, it's just something that manufacturers and users have to be aware of, is that these things are not 100% risk-free. And again, informed consent and warnings. I think the biggest thing is whenever you're putting out a device or a provider is relying on a patient to use the device, they have to appreciate that there are certain limitations to that device. Next slide, Derek. And I just want to quickly go through this because I want to get this over to Imran as well. But as far as data and privacy, I mean, those are obviously big things that you need to be aware of because the importance of personal health information. But the biggest thing is, I think we've seen different claims arise out of data breaches. And so there is a big risk as far as hacking and ransomware. And that can be from an organizational standpoint. Back in September of 2020, a German hospital reported a patient fatality as a result of ransomware. And then recently in the United States, a hospital in Alabama was sued in a birth injury claim because they said that the fetal monitoring system went down for a period of time. And so the obstetrician wasn't able to monitor the baby's heart rate and deliver timely, which resulted in injury to the baby. So again, I think that the concerns about hacking and data breaches are real. If you just Google it, you will find all types of articles on how there's concerns that these remote EKGs and Holter monitors can be hacked. And so the concern is just that folks know the limitations of those devices. Next slide, please, Derek. So these are just some examples of the telemedicine claims we've seen from Beazley's perspective. And again, I don't want to spend too much time running through all of them, but we've had several that deal with failures of fall detection pendants, where you've got, again, a user relying 100% on something. And when there's some kind of failure, whether that's from the user's perspective or from the manufacturer's perspective, personal injury results and you have a claim. We had a situation where a nurse was providing out of hours care and failed to appreciate the gravity of the patient's condition. The next day, the patient was rushed to the hospital and diagnosed with meningitis. So again, I think telemedicine providers have to appreciate that when a patient makes a telemedicine visit, they are subjectively telling the provider what their complaints are, and the limitations are that the provider can't necessarily do a full assessment of that patient and that patient's condition. So that was a situation where the provider should have probably elevated the patient's care and sent her to an inpatient visit. And then at the last example is kind of what I was speaking to previously about these home devices, is you've got a patient and a provider relying on oxygen saturations from an oximeter, and the patient passes away, and then the readings are not stored or verified. And that is more an issue of, once the claim results, if you have those types of devices, you need to make sure that you've got the software that's going to capture that data and maintain that data. So if a claim arises, that can be used to either defend your care or to prove that the patient was actually okay, and contrary to what the patient's claims are going to be. And with that, Imran, I'm going to hand it over to you.
Great. Thank you for that, Heather. That's super helpful, and actually lays the groundwork for a lot of the points I'm going to be discussing over the next 15 to 18 minutes with our audience. And just to give folks a bit of perspective, the work I do, one on the technology side of things. So when Heather, for example, was talking about telemedicine, and quite frankly, during the pandemic, the acceleration of not just development, but its rollout, that's something we saw real time over those 2 years between 2020 and present. And the other piece I'm going to be talking about, in which we practice, is the aspect of privacy and cybersecurity, which are areas that I think everybody is thinking about. Certainly you're reading about it, and there's some key things to keep in mind from a Canadian and certainly global perspective as well. So on this slide, what I want to do is spend a little bit of time to give you a bit of an overview, just a bird's eye perspective of where we stand in these laws that we have when it comes to privacy in particular. So Canada is a federation, as many of you know. We have a mosaic of privacy and data protection laws across the country. You'll see there's 24 privacy laws that are out there. Actually, there are probably more, because sometimes you have legislation which is adopted, which only has a couple of provisions that touch on privacy in particular. So you really have to navigate through these in real time. But in essence, you have federal legislation, sometimes public sector, sometimes private sector. In other cases, maybe sectorial, so maybe dealing with health issues, and we have provincially a lot of health privacy legislation in each province. And then more importantly, you will also have private sector related privacy laws. In a given situation, you can have a scenario where personal health information is involved, but you may also have the application of federal or provincial private sector legislation. So it can be a bit tricky to navigate through all of those. The bigger piece of concern that comes across is, given how our healthcare system generally is designed in Canada, in any province, quite frankly, it's an ecosystem. It is not necessarily centralized and it's not necessarily decentralized. You do have funding that comes from the provincial government, but the fact of the matter is, at the end of the day, you may have core services where delivered, for example, through hospitals or other key service providers, and then you have an extended ecosystem where you may have delivery of services and other ways of communicating with patients in real time. Each one may have access to information, in particular personal health information, which we commonly call PHI. And the custodianship of that is often something tricky to track as well in real time. The bigger problem is when you have those relationships, if you're the one collecting the information in the first instance and passing along to another party, or if you are that party that is receiving that personal health information or just information that is sensitive in nature, at that point, you want to make sure you understand what your contractual relationships require you to do. And you'll probably see language in your agreements that will talk about compliance with all applicable laws. And that's something that you should pay some attention to. Some of the recent contracting and drafting we've seen in these contracts are very, very specific and granular. You want to move away as much as possible from applicable laws to specific legislation that applies to you. Otherwise, it may be a blanket situation that you're dealing with, which has significant, not just enforcement, but in terms of penalties and enforcement action, generally speaking, as well. The other piece that we come across a lot in these agreements are the breach notification obligations. When do you notify the party that something has gone on with your information that you had collected either directly or from that other party? So for example, you're a hospital that collected the information or a clinic that collected the information in the first instance, and then you're using technology, for example, for telemedicine purposes, and you're using a third-party vendor's application, that third party may have a breach. When are they supposed to let you know? Is it when there's a suspected breach? Is it when they confirm there's been a breach? And what level of granularity do they have to provide to you other and beyond that initial notice? Are they going to cooperate with you? Are you going to be part of the updates? Those are all details you should have an open and frank conversation about. And I'll be honest with you, a few years ago, if you were to raise these issues, it probably would have been a bit off market. But given the prevalence of breaches that are occurring, especially with third-party vendors, the number of times that we see these obligations being built into contracts has increased significantly. And then the last piece, which is probably the most challenging part in any kind of discussion for negotiations, when you have two parties involved, are what happens if something goes wrong? Who's going to pay the bill at the end date? What are those indemnification costs going to look like? And again, we're going to very specific language. No longer is it sufficient to say our contract is worth $100,000, therefore we're going to pay you up to $100,000 in case of an issue that occurs like this related to a breach. You are seeing now standalone provisions that are talking about breaches, what the cost would be for attorney fees, for example, or any kind of credit monitoring to the extent they would be applicable in that kind of a scenario, call center services, and so on. So the granularity and the breaking out and carving out of indemnification is being built into these agreements in a very specific way. Next slide, please. I apologize for the small font on this one, but I think it does give you a pretty good sense of what's going on. And I want to talk about cyber threats generally when it comes to technology. And you have some stats and data, but I want to give you a bigger picture story here. And if we could just move on to the next slide, because I'll tie it back into this one in just a moment. So during the pandemic, what essentially happened was all organizations, as Heather was mentioning earlier, accelerated their digital transformation initiatives. So either it was through the adoption of more telemedicine, incorporation of technology in the practice of medicine, or just delivery of healthcare services increased in a material way. And as they were accelerating this, the technology that underpins it was something like you see here in front of you. So you would have, for example, on this triangle, this is your IT environment, if you want to call it that, you would have on one side of it data, so the data you're collecting about patients or other individuals. You would have the software, which is basically application that's been built to deliver that service. So think of, for example, even a Zoom meeting and so on. If there's going to be some back and forth, the software is going to be the Zoom software. And then there's the hardware. So this is the device on which this service or this software is going to be running. So it could be your laptop, it could be your portable mobile device, like an iPad and so on. So with this IT environment, and as you're accelerating your digital transformation, because you want to get to market, you want to deliver services quickly, you can't wait 4 or 5 years to do beta testing and make sure it's fully secure. A lot of things were being done probably not as securely as it should have been necessarily. And what the hackers were able to do is they're looking for vulnerabilities constantly. They're looking for opportunistic attacks that they can implement to make sure that they can actually hit one of these 3 or more of these IT environment vulnerabilities. So either they're going to try to snatch data, which is really key for them because data has value, and I'll talk about that in just a minute. Either they're going to attack the software because there's a patch that wasn't put in there, or they found what we call a 0-day vulnerability, which is basically a vulnerability in a software that nobody has discovered yet. Or in very rare instances, they're going to attack hardware, which is very difficult to do and seldomly ever done. But generally, data and software are the points of entry for these attackers. So if we could just go back to the last slide for a minute. What we saw during the pandemic, which is very interesting, is a targeted attack on 2 types of information. So they were attacking organizations that collected either financial information, because it is deemed to be very, very sensitive under privacy legislation in Canada, or more relevant to our conversation, personal health information. And the challenge with personal health information is, contrary to financial data, it is very difficult to remediate. Our privacy laws are very broad. So when we talk about a privacy breach that could cause a harm to an individual, it's not just identity theft. It could also be a reputational harm. So if you have an individual, for example, who's getting a diagnosis, they may not want that to be publicly disclosed. And if it is because as a result of a breach leaked onto the dark web, the challenge here is you don't have a tool or a solution like credit monitoring, for example, to offer those individuals. So when it comes to health information, especially with the acceleration of telemedicine as a service delivery method, the quantity of data that was being collected and still is, and where and how it's being sourced, and where it's being kept with multiple vendors, it's not one organization collecting all of it, has resulted in an increase in the number of breaches that we've seen in Canada over the last 2 years. So globally, certainly that's the trend, but in Canada in particular, you're seeing a lot more of those. One additional quick point, and I'll be remiss if I didn't mention this. Ransomware has been the flavor of the month for the past 2 years. And most people, when they think about ransomware, they think of some young kid in a basement with a hoodie on with multiple screens who's hacking into systems and so on. It's actually gone much more sophisticated than that. It's a full-on business. It is, and it may sound a bit counterintuitive, it's almost like a supply chain. You have one group of attackers who are just trying to steal credentials, username and passwords to get into your system. They take that information once they have it, pass it along to the second group, which is going to go into your system and steal data. They're very, very focused on finding valuable data. They'll move around your environment to be able to figure out what is of value to you, identify it, and pull it out over a long period of time. So we're seeing in some cases several terabytes of data being exfiltrated or taken out of the environment in a material way. And then once they have that data, they'll let the third group know, say, hey, we've got the data, you can go in and lock up everything, which is the encryption, or what we call the detonation of the ransomware. And then lastly, down the supply chain, you have these negotiators who are basically going to try to put pressure and say, you owe us X hundreds of thousands or millions of dollars if you want A, your data returned, or B, you want the decryptor to be able to re-access your information. So as you can imagine, the more folks you have in the supply chain, the more mouths you have to feed, hence the quantum of the ransomware or the ransom demands has gone up significantly as well during this period. I'll tell you also that given the sensitivity of PHI in Canada, but globally as well, there's a much more of a willingness in some circumstances where clients say, we may be willing to actually make a payment. There's a whole discussion we can have, and happy to take those questions later on around whether it is legal, appropriate, and recommended to make a payment. And there's a lot of considerations that go into it. It is not an automatic that you should pay. As a general proposition, we at our firm Norm Rose recommend not to pay as a starting point, but we understand that there may be some circumstances. So there's a broader and more relevant discussion to be had on that front. If we could just move on to the next slide, past the next one after that. Thank you. So I talked a little bit about this, about vendors, and it could go both ways, business partners or other folks, but in the healthcare system, ecosystem in particular, you have a lot of data which is always transiting throughout the system. And so what you want to make sure is when you're contracting, and we often have this with our clients, they'll get a business unit coming in or a division coming in and saying, you know what, we've got this great technology that's going to make the delivery of telemedicine so much more simpler. Can we sign this contract? And by the way, they've got a great website. Here's our standard terms and conditions. That's not the best way to proceed. What you want to do is do some level of diligence, because if there was to be a breach with that vendor, or if a regulator came on knocking on your door, like the Office of Privacy Commissioner here in Ontario, you want to make sure you can demonstrate the following things: that you went through a vetting system. There's a series of 60 questions, for example, that we submit to our clients to consider, which is broken down by administrative, technical, and physical safeguards that the vendor is going to be employing. And based on that initial questionnaire, you can qualify it as being high, medium, and low risk. Based on that risk analysis, you can then contract specific clauses. So for example, if the risk is very low, let's say you're not collecting a ton of PHI, and the relationship is going to be relatively straightforward with limited, if any, personal data being transferred, at that point, you can have more modest or more less onerous conditions put into the agreement. But if you're sharing the most critical information, the crown jewels, and if there was ever a breach, you would be potentially exposed to significant enforcement action or possibly even litigation. At that point, you want to put more robust contracting obligations along the lines of what we discussed a couple of slides ago. And once you have the contract, more and more of these are not only for 1 year, they're for multiple years, 2 years, 3 years. I've seen up to 5 in some cases before renewal comes up. You want to make sure during that period that the vendor is keeping up. Technology is changing, best practices, whatever best practices is at any given time or industry, will need to be reevaluated very, very regularly. And so you want to have an audit or a review process in place where you can actually demonstrate that. Next slide, please. So very quickly, I think when a breach occurs, and we can walk through a bit of a scenario if you like. So let's say you are in the ecosystem, you are offering telemedicine services, you had a technology component, whatever it may be, to deliver that service, or you're the service provider itself, and you have a breach. No fault of yours, the breach happened, you had the best practices in place, but the attackers are sophisticated. They're able to get in, steal some information, and then obviously encrypt your data. Let's say in the best case scenario, you are able to restore from backups because you had viable backups. The question then becomes is, what do you do next? Pay or no pay, your obligation if data was taken, if you lost custody of it, will be to notify individuals. So you have to start thinking about the process after the breach occurs. And so number one, you want to quantify what you need. Do you need to pay a ransom? Yes or no? Who do you need to hire? Not to sound self-serving, but you want to have a breach coach, which is typically a law firm or a lawyer. You want to have forensic experts. These are folks who are going to come in, build a chronology, and understand how they got in and what they acquired. Will you have to offer some level of credit monitoring and so on? So there's going to be significant costs that you need to think about right up front and get the right vendors in place. And hopefully, if you have the insurance, be able to rely on your insurer's experience and their panel vendors to be able to draw on their expertise. Once you have that, and let's say you're at a stage where you can now go ahead and notify the affected individuals, you want to make sure you've thought about who your key stakeholders are. Certainly you're notifying your board if you have one. Certainly you're notifying your business partners to the point that they're impacted. You're notifying your key clients or patients or any other key stakeholders in that ecosystem that may want to know or be impacted by this. You may also want to think about sort of public relations. You also probably want to be engaging with law enforcement, especially if there's some kind of data theft component to it or a ransom demand that went along with it. And then obviously you want to engage with the right regulatory authorities from a privacy and health perspective as well. But the bigger piece I'll tell you is when we speak with our clients, certainly legal is a concern, but it's not the primary driver. What they're concerned about is twofold. One, what is our downtime going to look like? What is the operational impact that's coupled with the financial down the road impact from this? And then secondly, what is a longer term reputational harm, if any, to our brand or to our relationships with our key business partners? And that's where engaging and being as transparent within reason that you can be with your key business partners and the public and patients is going to be absolutely critical. Maybe a crisis communications firm is something that you may want to consider at that point as well. Next slide, please. We can skip this one because I think I've covered the fact that the cost of ransomware or ransom payments has gone up year over year, but just sort of gives you a good sense of what's out there. And often I find my presentations seem to be a bit gloomy. So what I've tried to do is share with you some best practices. And here's the good story in all of this. The court and the regulators and the public generally as well recognize that organizations are trying to do their best. And if they do have a cybersecurity incident, for example, that they're also victims in this process. It's not the when you have a breach, it's going to be the how you respond to the breach. And a great way to mitigate some of the negative impact is going to be to implement these 5 quick wins within your organization, which I'll go through very, very quickly and then hand this back over to Derek. So number 1, you want to be able to do a tabletop exercise, meaning test your plan, see how it's going. Are you able to respond as well as you think you can that's written on paper in reality? Number 2, to the extent you can get cyber insurance in place. I'm not a cyber broker or an insurer, but I would say every client who has cyber insurance has benefited from it, primarily because of the next one that you have here, which is you can pull and tap into their experts. The insurers have gone through all the work already. They've vetted the experts for legal, forensics, credit monitoring, and so on. And they've also pre-negotiated rates, which are discounted. So you benefit from discounted rates if you can get the insurer's panel access. Secondly, you want to make sure that as you're changing and as you're evolving and you have new implementation of technology in your environment for the delivery of telemedicine, that you're staying at the cutting edge as much as possible, balancing cost and benefit, but also with minimum requirements along with best practices and trying to figure out what the delta looks like between those two and trying to always strive for the best practices in place. The reason being is if you're not doing that, at some point you're going to have a breach, your clients will be testing you on those pieces as well. And then lastly, probably not as fun, but super important, is understanding what your universe of data looks like, understanding then what the worst case scenario may be. If you did have a breach, which was medium, high, or low, what would the outcome look like? And just basically gamify that. And that will give you a very good sense of where to invest your dollars to get the maximum ROI on those. I'll stop there, but looking forward to your questions and back over to you, Derek.
Thank you very much, Imran. Thank you, Heather. And thank you to everyone listening to this sponsor symposia and for joining us today. We do have a couple minutes left. So if anyone has a specific question they would like to ask now, do feel free to pop that into the chat and we will do our best to answer. Otherwise, you'll see our contact details on the screen now. Feel absolutely free to reach out to any of us with any questions. We'd love to hear from you. And in absence of any questions, we will encourage everyone to now move over to the closing keynote session, which can be accessed at the top of the virtual event platform for an engaging presentation by Dr. Brad Nider, the Healthy Humorist. Thank you all for your time and for joining this afternoon. We really appreciate it. Take care.